Good evening, everyone. My name is Victoria Vinova, and I am R&D Strategic Lead here at Serpentine. And it's my pleasure to welcome you all tonight to this event, from theory to practice, building tomorrow's data infrastructure for public AI. So on tonight's panel, we'll be discussing one of the thorniest and simultaneously most fascinating topics in AI today, the novel ways for structuring the relationship between training data and AI development in order to create a more pluralistic and symbiotic ecosystem. So much of the excitement around AI in 2024 has been somewhat overshadowed by concerns that with the large foundation models being trained on what is effectively the internet, with no voice in the process or compensation, to continue developing AI in a way that is more inclusive and oriented towards public interest would desperately need mechanisms and infrastructures for more equitable alternatives. So many reports by organizations, by people in this room, such as the Ada Lovelace Institute, the ODI, and the Turing Institute, have put forward possible paths forward, advocating for the advancement of participatory data stewardship and innovative uses of cooperatives, trusts, and company structures to configure the ecosystem for AI in a more balanced way. So inspired by this work, for the last 9 months, we have been running an experiment around participatory data stewardship and the setting up of a Trusted Data Intermediary at Serpentine in conjunction with a call, a commission by Holly Herndon Mat Dryhurst, currently on view in the galleries just on the other side of this wall. Hopefully most of you had a chance to see it. If not, the show is open until early February. And we hope that the quite concrete results and hopefully transferable insights that were obtained through this experiment turned reality can inform the current government's ambitious plans for AI as an economic driving force and the role that trusted data intermediaries could play within that, and also serve as a precedent for other organizations in the cultural sector and beyond to set up similar arrangements. So to start out, it's my honor to introduce tonight's panelists, and some of the people here and also on the screen, hi Cullen, were part of the project team, and some have inspired this project. So unfortunately, Rima Patel, co-founder of the Ada Lovelace Institute and director of Elgon Social, has fallen ill and won't be joining tonight. So as many of you will know, Rima was a co-founder of Ada and established the work in public engagement and participation. And so her contribution will be missed, but hopefully, Jack, you will be able to fill in some of these gaps. So we're lucky to have with us Jack Hardinges on the other side here from me, who's an independent advisor to organizations that research, build, or fund new data products, systems, and infrastructure, and serves as fund lead for the Data Empowerment Fund and board member of Open Supply Hub. Previously, Jack was head of programs at the Open Data Institute, where his work advanced the understanding and practice of data stewardship, privacy-enhancing technologies, and participatory approaches to data. Over the past 10 years, Jack has published on topics including data rights, the economic impact of data, smart cities, and the transparency of foundation models. And here on the screen to my right, we've got Colin Miller calling in from Berlin, where he's currently the VP of Policy at Sponning, an organization building data governance solutions for AI training datasets. Previously, Colin worked on the design and engineering of technical systems for large-scale immersive media-based architecture projects, serving as the principal system engineer at the Sphere and numerous other immersive environments. And now moving on to my dear colleagues and team on the project Serpentine, Jennifer Ding, Alistair Taylor, and Alex Lawrence Archer. So with Jen, we've been working for almost 10 months now as co-leads of the research project. We initially recruited Jen as a data trustee in training, in quotation marks, with the aim of shaping the participatory and data governance side of this project, as well as specking out a new data stewardship role to be put forward as a recommendation to other cultural organizations. But in reality, it was not so much that Jen was at training as it was us, Serpentine, whereby we were exploring the contours and responsibilities of a role that aims to build new organizational practices around data in relationship to AI. So Jen is an engineer and researcher focused on advancing best practices for open and participatory approaches to data and AI. She's on the AI solutions team at NCORD and co-founder of London Data Week, a citywide festival of data. Now, without Alex and Alistair, none of the legal concretization, which was critical for making this experiment work in practice, would have eventuated. Alex, so further away, next to Jack, is a solicitor at AWO, a data rights agency where he works in advisory and contentious matters at the intersection of data protection, privacy law and public law, AI and new technologies. And Alistair is partner at Keystone Law and has spent over 20 years working at the interface of law and technology. So the flow of tonight's event. First, I'll do a little bit of scene setting, and then I'll pass on to Jen, Alistair, and Alex to share further details about the project. Then we'll have a response from Jack, followed by a response from Cullen. We'll transition to a conversation and would like to involve you as soon as possible in the conversation, as I'm sure many of you will have interesting insights and questions and feedback. So without further ado, let's dive in. Just to give a bit of background to make sure we're kind of all on the same page as to why we're here at Serpentine tonight. Since 2020, Serpentine Arts Technologies has been running a research and development initiative called Future Art Ecosystems, or we abbreviate it as FAE. And FAE's mission is to enable a context for art and advanced technologies that is future-facing and advocates for public interest in the emerging technological landscapes. So our primary focus is on research and on carrying out experiments, either in conversation with art commissions, as was the case with the call, or as part of broader partnerships. Specifically, our work in AI has evolved from the Creative AI Lab, which has existed since 2019 in partnership with King's College London, through to Future Art Ecosystems 4, Art and Public AI. You can actually see the publications here. A strategic briefing that was published in early 2024, and finally to the invitation of the initiation of the experiment as part of the call, with initial support from Sylvie Delacroix at the Center for Data Futures, King's College, and Matt Pruitt from Radical Exchange. Sorry, there's a bit of coordination here. Okay, so we believe that this ability to do research as part of a broader community of organizations and researchers, then to be able to test proposals in real time through ambitious but fairly contained experiments, and then use the findings to further inform decisions in the cultural, technology, and policy domains is quite unique to the art and technology space. And this breadth of scope highlights that when artistic and technological processes come together, there's an opportunity to develop not just new types of artworks and experiences for audiences, but also new technological approaches and legal precedents. And this really came through in some of the proposals and recommendations that we make in Future Art Ecosystems 4, in response to the question, can culture contribute to the development of public interest AI by becoming a space for agile experimentation? And if so, then how? So cultural institutions are the prevailing stewards of historical and evolving cultural artifacts and narratives, all of which in the context of training generative AI models become training data. Now, this predicament calls both for a strategic vision for how such data is to be stewarded legally and fairly, as well as practical, context-specific implementations that make sense in concrete organizations. And this ties in directly with the need to nurture a general culture around AI, where AI is not just perceived as a new set of technological products where everyone is a user, but a public infrastructure where pathways for agency can be found at different levels of the AI stack, or at the very least in the context of data and model development. This is particularly urgent for art, culture, and creative industries, but equally any domain that wants to shape how AI can positively transform their field. So in our context, a collaboration with artists Holly Herndon Mat Dryhurst and the French Public Audio Research Institute, IRCAM, presented an opportunity to test such pathway for a curated training dataset. And some of you have heard about this already from my colleague Eva, if you were here for the tour. But just to repeat for those who weren't part of the tour, 15 choirs from across the UK were invited to record performances of a songbook composed by the artists, Holly and Matt. The compositions and recordings were optimized for the collection of a choral AI dataset, purpose-built for training choral AI models for the exhibition. The key objective of our experiment was to develop infrastructure for the stewardship of the dataset that upholds the choristers' intellectual property and data protection rights and reflects their more general preferences relating to the uses of the dataset, balancing those with the interests of other stakeholders in the context of the call and beyond, whilst also, and this is very critical, enabling an operational model that is sustainable and realistic. Now, kind of coming to the conclusion before I pass on to actually give all the details and kind of the juicy insights, but I think it's important to kind of focus on the two main interlinked insights that emerged through the process. So the first is around the need to build mechanisms that go beyond opting in and opting out. And that seems to be a horizon around which EU and UK policy is currently frozen around. So we hope that this primitive here can move the conversation further in this regard. And this seems like a particularly important goal for public interest AI infrastructure if the idea is to help level the playing field and create greater symbiosis between AI development and creative communities. Now, secondly, what we learned is that while individual data and IP rights provide an important legal footing, they prove insufficient in practice. And here, the cliffhanger, and here we move on to sharing the actual juicy insights from the project. So, Jen, I pass it on to you, together with the clicker.
Thanks, Victoria. So hi, everyone. I'm Jen. I was the data steward on this project. And it was really an amazing opportunity to, as tonight's event is named, test the application and practice of some of the concepts that the responsible AI field has wanted to advance for a long time. So things like bottom-up or community-driven data governance, and different kinds of activities from, on one end of the spectrum, data transparency, all the way to the other end towards data empowerment and other loftier goals that we might have. So in my section, I will share some notes from the field, so to speak, for what we did, what we found on this topic, building capacity for collective data governance with the UK choirs. So these were the three main goals of this part of the work. When it comes to a data set, even though all of us are part of data sets together, it isn't really natural to think of that as a group identity, but that is functionally how our data is being used. So one question in this case was, among the different contributors to a shared Coral AI data set, what might it look like to build that collective identity that could then enable collective action? Things like making decisions about the data set, thinking about the implications of how the data set is used on yourself, your choir, but also potentially other choirs that are in the data set as well. Number two, inspired by one of our advisors, Sylvie Delacroix's work, thinking about what might it look like to enable bottom-up or community-driven development of the governance mechanism that is chosen for this group. So something we didn't want to do was to come into the project and say, this will be how we govern it, this is the structure, whether it's a co-op or a trust or these different forms that do exist and have been tested by many different organizations, many of whom who are in the room tonight. So in fact, what we wanted to do was, what if we gave these choirs, these choristers, some background on what is available and let them guide the formation of the governance mechanism that takes place. And even though it's not bolded on the slide, one crucial bit was that we wanted to make sure that anything that was developed actually had teeth, so it actually had legal backing, so that it's something that could have real consequences if the objectives were not met. And finally, one of my favorite quotes, I think Victoria said this early on in the project, was, in many ways, our project was kind of like live-action role-playing or LARPing, what good faith AI development looks like, right? We have artists who are interested in giving away power. We have lawyers who are working with us to enable giving more rights to data contributors, which really isn't a very common scenario that we're in very often. But since we have this interesting environment as part of the art project, what can we explore? What new best practices can we create so that our project can be a best-in-class example for future projects like ours? So none of this project would be possible without these 15 UK choirs that you see on the slide here from all over the UK. Here was the timeline that we had. I've learned through this project that art timelines are extremely tight, so it was a really intense sprint for 6 months to work with the choirs. They also, had to actually record the data set. So all of that work happened very quickly. We also had one-on-one conversations with the choirs over Zoom. Then we held some choral data conversations open to any choir member who was part of the project. Then we released a data preferences survey to gather general thoughts on how the choristers felt about how their data might be used for the project and beyond. One interesting finding that came out of that was people actually wanted to get more involved. So then we set up a data governance working group, et cetera, et cetera, et cetera. I won't read the entire slide. But maybe for now, just to highlight some quotes that came out from these conversations. So the choirs said things like, "Our voices belong to us." This was something really important when thinking about the ownership of the data set, or ownership is the wrong term, but who was able to make decisions about the data set. Another interesting point was thinking about what does it mean to think of something like choral voice as data? How does that feel? And we had some interesting quotes that was surreal, interesting but scary, and unmusical, disembodied, and soulless. I won't read out the long text, but I think the gist is that many of the choir members that were part of this project, this was an opportunity to also just have conversations about data and AI and what's happening, especially in the generative AI space, especially as things are moving so quickly. People feel like they're in some ways being left behind, or they have no voice in this process. What does it look like to create spaces so people can have a voice, at least in some of the data sets that they are a part of? So one thing that the survey helped us do was identify targeted interventions across the model building pipeline for the choral AI models. It set priorities for things that we wanted to make sure were followed. So there were some requests around data transparency, around who had access to the data. Was it stored in EU versus UK versus US servers? And something that the choirs were interested in getting more involved with were, I'll highlight two areas. One was around defining unacceptable behavior for the model, so saying hateful language or language that did not align with the values of the choirs, and also getting more involved in defining what recognition and use looks like in the future. So setting license terms, for example, if the data set were to be released in the future. So the next two sections, I'll highlight two key activities that we did, the data preferences survey and the license preferences policy, but I won't go too deeply into the graphs because it's not the time for pie charts right now, I think. So this was the first survey we did. This was a data preferences survey that we sent to all of the choir members, had over 100 responses from across the 15 choirs. General findings were quite interesting, so this pie chart highlights that the real takeaway is that it really matters to the choir members who has access to the data. It's not really about the fact that it's being used to train an AI model. Thinking about Holly and Matt, the artists, who many of them know, many of them had spoken with or were aware of what their work represented, this was something that they felt much more comfortable with, this group of people and this group of artists training an AI model versus just any general user. So it was interesting to see that sort of contextual shift. It wasn't really about AI training itself, but more about who had access to the data. Another interesting point was around recognition. So the choirs weren't really interested in individual recognition, more interested in choir level recognition, which I think spoke to the kind of identity that many of them had and how they thought about the data set. Another interesting point is that they were interested in getting more involved in governance, which is what led to the creation of the data governance working group. So the last example I will power through is an example of a polis that we set up to try to gather preferences towards potential future use cases and implications when setting a license for the data set. So for those who may not have heard of Polis before, it's an online tool for gathering different responses from a group of people, and then finding the different clusters of preferences that exist, which can then help making nuanced decisions or responding to a plurality of different views. So in our case, we had different statements that were represented. So things like, should people be kept up to date on usage of the data? And then people just vote agree, disagree, or unsure. And the respondents can also submit statements for other people to vote on as well. So again, another really small chart, so I'll just give you the takeaway. There was a lot of alignment across the board. That's what the green bar shows. But we did have 3 different clusters, opinion groups, that emerged from the whole group. So we have group A, B, and C. I think it was groups A and B who were more hesitant towards open sharing of their data. They wanted very clearly for the data to not be used for commercial use cases, so for profit. And they were not really interested in like a wide public release of the data set. We had another cluster who was a little bit more open to that. I think it was cluster C. In the future, this could be a way, for example, where we decide how we release subsets of the data set that can match preferences from these different clusters. But ultimately, what this revealed to us is that if the data set were to be released in the future based on a decision with our acquirers, the most appropriate license that matches the outcomes from the polis is something like this license from the Creative Commons license family, which requires attribution, so giving credit to the acquirers that were part of it, non-commercial use cases only, and any future release of the data set would need to respect these same terms. So I think with that, I can pass it on.
Hello, I'm Alistair Taylor. Along with Alex, I helped advise on the legal aspects of the project and also produce the documentation to embody these ideas. So I think the first slide asks the question, how can legal mechanisms support sustainable data governance? That's the sort of Jen's lofty question, I think. The more perhaps down-to-earth lawyer's question is, what problems do you face turning these lofty ideas into documentation that's going to be acceptable to all of the parties involved and enforceable and fair? And we faced a sort of range of issues which we're going to deal with fairly abstractly here. Firstly, when you ask someone, do they want rights? Of course, people want rights, but rights go with obligations or restrictions. So we found very quickly that trying to, simply taking the rights that were requested and putting those into the documents meant that we had a contractual or a licensing situation that wasn't necessarily acceptable to the data intermediary. There was also a conflict potentially between the individual choristers. If one chorister, one chorister wants to be able to refuse consent to something and 10 choristers do consent to it, what does that mean for the outcomes? A slightly different problem we faced was perhaps being instructed by pie charts, which is the first time that's happened to me in my career. And there's no obvious way of turning a set of pie charts into legal clauses. To take one example that I saw in the data there's 75%, I think, of respondents wanted the data set to be gated, whereas 30% wanted it to be freely available. And even where there was a clear majority in those pie charts in the surveys for something, that didn't necessarily give us an answer because, do you interpret that on a first past the post system, or is it proportional representation? Do you try and get something that would sort of be the mean of all these views, or do you... Yeah, it's not straightforward to turn that into legal documents. There's also various legal issues that limits of what we can do with the law. In relation to intellectual property law, which is my area, rights are the rights are defined in statute, and they there's some things they don't cover. For example, there's a set of defences, fair use in the US, fair dealing in the UK, that the IP rights won't help you with. If you're trying to use the law of contract, then you've got to deal with the doctrine of privity, which means that you can only impose contractual obligations at all on a person you're contracting with. You can't do anything about third parties, at least not directly. And there's also issues with GDPR rights that Alex is going to talk about shortly. Then there's the question of just practicality. We needed to produce documents that all of the choristers would sign. And how many choristers were there? 1,500? No, 400. Yeah, that's not a straightforward task. I think the last point on the slide there, was sustainability. So there's also the question of how do you structure the legal bodies and relationships in a way that means this is going to work going forward. If you have an individual appointed as the data trustee, what happens when they want to do something else? If you have a company, then who owns the company? Who is responsible for managing the company? Who's paying for the administration of the company? So, in short, there was a lot of different practical and legal issues that we had to face.
So Alistair's hinted why this was quite difficult. We were really trying to reflect or enact this ideal of like collective or bottom-up or whatever you want to call it governance in like legally enforceable mechanisms. And we keep using this word rights, but that concept requires a bit of unpacking, because the idea of collective governance presupposes that the individuals who are going to form part of the collective have any right to participate in the governance of the data set at all, or at least some leverage that they can use to get participation in that governance. And that's not like maybe as clear as it might initially seem, or certainly not to the layman anyway. And what you see when you start to look into it is that people often think they have more rights in relation to their data than they actually do. One of the quotes, Jen, that you had was, our voices belong to us. And, well, I mean, from a data protection perspective at least, and certainly when those voices are recorded en masse as part of a choir, that's probably not correct, actually. But that just shows you the kind of starting point that people are coming from. People often think that they own their data, or that nothing can be done with their data unless they consent to that. And those would be two quite serious misconceptions in data protection law. So really to do this, to work through this legal task, we had to go back to basics and figure out, okay, well, what rights does anyone have in relation to this process of AI training and deployment? And there were two sort of areas of law which were plainly relevant, which was data protection law and IP laws, like how come we were doing it. So I'll talk about the data protection side. Is that right? Oh, God, bloody hell. Hold on. On the data protection side, talking about rights arising under GDPR. And to reiterate, it's not about ownership. You don't own your data. You have certain rights which arise in relation to processing, but only where that processing enables your identification. And that became quite important in an interesting way in this project. So you had to break down the stages, like what's happening and when, and what acts of processing does that entail, and who, if anyone, is identifiable at each of those stages. So if you think about the training stage, where you're using the recordings to train the AI model, we know that the individually mic'd singers, there were some soloists who were mic'd up separately, and they had tracks that were recorded against their name. Okay, so they're definitely identifiable. And when you use that recording to train an AI model, that's an active processing which enables them to be identified. But it's actually different for the ordinary choristers, because once their voices are recorded on those tracks, you can't identify them, or at least not by any reasonably practical means. You can't single out one voice from the choral ensemble. So actually, even at that early stage in the AI training process, the ordinary choristers, the non-soloists, didn't really have any GDPR rights that we could see. So you're already starting to see some of the limitations there on the GDPR side. And then when you get a bit further down the AI chain to the deployment phase, well, then you're talking about like a composite Cora model that doesn't like imitate or replicate any particular individual's voice. So again, that wouldn't really be an act of processing that enables anyone to be identified. So again, like no GDPR rights there as well. So that stage at which the GDPR rights arise is quite important, and we'll come back to it later maybe. So is there anything else I want to say about that? Okay, but the soloists did have some rights, some GDPR rights. And sort of in brief, we're talking about they're entitled to be kept informed about how the data sets, so like the recordings of their voices, how that's going to be used. They can object to processing of their personal data in certain circumstances, and they also can maybe seek erasure of that personal data. And it's probably worth adding that there likely will be some acts of processing of that personal data which are like automatically unlawful for want of a lawful basis. Like if you can think of something, I don't know, like think of the most offensive thing you can imagine, like being done with the recording, like that probably wouldn't be lawful anyway, because it wouldn't be justifiable on the basis of your legitimate interests. So yeah, there is some leverage there for the solo singers, but it's more limited than it maybe initially appeared, and it's probably more limited than the choristers thought when they were at the outset of this project as well. Fancy you.
On the other hand, the choristers, at least based on some of the comments I've seen, weren't necessarily aware that they had intellectual property rights in their performances. So performers' rights are a special kind of copyright. They're set out in the UK law in the Copyright Designs and Patents Act, and in many ways they're very similar to standard copyright. If you read through the act, you'll see it looks a little bit like the copyright provisions have been cut and pasted and then changed a bit for performers' rights. They include both economic rights and moral rights. So economic rights are those generally that can be licensed and in some cases assigned, whereas moral rights are rights that attach to performers as individual artists. So an example of a moral right, and I think the key right we discussed here is the right of attribution. So if a person makes a qualifying performance and that performance is published, then subject to the right being asserted in a document, there must be attribution, that performer's name, or in some cases group attribution, so the choir's name must accompany the publication. Economic rights, on the other hand, are concerned in as a matter of kind of English law theory, at least, with promoting the production of artistic works in a sort of quasi-business context, and they are, again, the core rights there are recording, so you need the permission of the performer in order to record their performance. Reproduction, you need permission in order to reproduce a recording of a performance. Distribution, making available. These rights can, for the most part, either be assigned, these economic rights, so that means that these are property rights, they can be transferred, or they can be licensed. So that licensing is when a person having a right gives another person a right to do something which would, but for that grant, be an infringement of the right. So, go to the next slide. Yeah, so we took these rights and first of all advised on the question of how they fit into the AI development process. And what we found is that the recording is obviously clearly an act contemplated by the legislation. The creation of data sets and copying to create data sets is clearly contemplated by the legislation. But the act of training the AI model, of taking statistical data from the recordings and taking that data into the model is, at that point, the legislation breaks down and it becomes very difficult to apply various concepts from the legislation to that process. And then further downstream, use of the model, distribution of the model, use of outputs of the model, it becomes very hazy. So we produced, though, we did the best we could with the legal limitations and produced a performance rights agreement. And the centerpiece of this is a license whereby each individual performer licensed the data intermediary, which we'll come on to shortly, to do certain things with the performances. I think, slightly inspired by the Creative Commons license, tried to keep things as simple as possible. We wanted a document that all of the choristers could read and understand, and I'm not sure we fully achieved that, but we went some way towards it. And the way we structured it was we had a main agreement which set out the relationship between the data intermediary and each chorister, and then we had a template license. And that license could be used by the data intermediary to grant sub-licenses of the data set. And it was also to save on words. We used that for the primary license from the choristers to the data intermediary itself, and just modified it as necessary. So that's the structure. And here, this slide just covers the content, which is, I think, I've mostly spoken about, but I think you had something to say about GDPR.
Yeah, well, just to talk about like third-party exercise of the rights that we've been mentioning. So, okay, you got these like rights floating around, and there are good reasons why the solo singers and the rest of the choristers might want to have them exercised by a third party or like on a collective basis. Like it's more like, and actually some of that was coming out in what Jen was telling us earlier as well. So like it's more efficient, it takes away the burden from those individuals. You might be able to mandate or transfer those rights to a third party that has a bit more expertise. So like, is it going to be able to exercise them in the right circumstances? And if you're collectivizing them, you have a bit more bargaining power. I think it's fair to say that on the IP side, having the third-party exercise of the IP rights is like quite straightforward. It's like lots of precedent for how that works. You like grant a license, and Alistair's spoken about that. On the GDPR side, it's definitely more complicated or more nuanced. You definitely can mandate the rights that I mentioned earlier, so the right to object, the right to be informed, and so on, to a third party. But it's definitely not a license. It's not a transfer, and we know that because even if you mandate the exercise of those rights to a third party, it doesn't stop you from doing it yourself. So it's quite unusual in that respect. And there are a bunch of other things that are quite unclear, partly because the GDPR is like a bit new. So, for example, if you mandate someone to exercise those rights on your behalf in certain circumstances, it's really not clear what obligations that gives that person. Like what happens if they don't do it, or like they do it wrong. We don't really know what the answer to that is. And I would also add, in my professional experience, third-party mandatees of GDPR rights face quite a lot of barriers to exercising them as well, because controllers are just often quite hostile, and they don't really get it, and they're not really willing to act on those mandates. So there's definitely complexities on the GDPR side for third-party exercise. But we didn't let that stand in our way. So we knew that we had a bunch of GDPR and IP rights that we wanted all like to be sitting together and exercised by a third party on behalf of the singers in the way that they wanted them to be exercised, so in the way that had been surfaced through the processes that Jen was talking about. So we needed a data intermediary, like some kind of body or person or thing to hold those. And so it got mandates of the GDPR rights, and it got the licenses of the IP rights and the ability to grant sub-licenses as well. So in that way, like the full leverage, such as it was, of the singers who'd contributed to this data set had all been moved to like one place and was capable of being like exercised or wielded by this intermediary. When the project started, I think there was quite a strong assumption that intermediary would be a trust, or that it would hold these rights in trust. And there are a few reasons why we didn't end up going down that route. That first bullet says GDPR rights cannot be the subject matter of a trust, and maybe like moderate that slightly. I mean, I would say it's far from clear that they can, or it's yet to be established. No one's done it. It's certainly not been like recognized by any court or regulator. So you'd have to be sort of like quite bold and ambitious to do that and expect it to hold up. And then a few other reasons around like limited liability. So, you know, that's one of the main reasons that like Jen is not the trusted intermediary, because then she would have like unlimited personal liability for things that might go wrong, which is probably not what she signed up for. And a couple of other things around like HMRC and so on. So yeah, that's how we ended up with a company limited by guarantee as the third-party intermediary holding the mandates and holding the licenses.
Yeah, I think this is just a summary of the overarching setup that takes us back to the macro level.
We're going back row.
Which is perhaps necessary
right.
at some stage.
That's good.
But no, go ahead.
Let's go back. No, it's good. This is the last slide. So we're just going to end on, as it says there, some like reflections or thoughts on wider implications maybe for the wider discussion. Obviously there were like lots. If I had to choose a couple of particularly interesting things, it really jumped out how the stage at which you seek to exercise GDPR rights is really crucial when it comes to AI training and deployment, and better earlier. And in fact, you may really like lose your chance if you don't exercise them at the training phase. They're not really well designed to unravel like the training of an AI model, because typically the deployment of that model won't involve the identification of any individuals unless it's being used to like search your name or something. So that was interesting. And also did you say LARPing earlier? Someone described it as like LARPing.
Exactly.
So there's a degree of artificiality in the project here, and particularly the choristers had more bargaining power than they probably would in a real world, like commercial scenario. And I think in a real world scenario, potentially the balance between GDPR rights and IP rights might be quite different, partly because you can't like trade away GDPR rights, so they could potentially be a bit more important in like a more commercial real world scenario, but it's like hard to predict how that would work.
Great.
Yeah. I thought that one of the interesting things that came out of the project in the light of the government's copyright and AI consultation, which, as you may be aware, seems to herald a change in English law regarding licensing for AI training. So the current position is a little bit unclear, but what the government is proposing to introduce is a text and data mining opt-out regime whereby anyone who has lawful access to a copyright work would be permitted to use that work to train AI models for both commercial and non-commercial purposes, unless the rights holder, which is a bit of a question mark over who that might be in complex works, unless the rights holder has opted out. The driving force behind this, or one of the key factors behind this, is that internationally, many countries do, or many jurisdictions do, allow training without licenses, and most notably in the US, the fair use doctrine, subject to quite a lot of litigation, but a lot of people think, at least, that the fair use doctrine allows copyright works to be used for training AI models. And if the UK doesn't find a way to make training lawful on a large scale, then models simply won't be trained in the UK. Again, going back to the point, though, that we found about the performers not necessarily being aware that they had IP rights in their performances, it does raise the question of how would they opt out if they don't even know they have the rights. And whilst the regime proposed by the UK government may well work for large media companies, I think it's questionable how well it works for individuals and smaller organisations.
Thank you so much. Okay, so let's move on to the respondent part of tonight's conversation. So Jack, if you could kick us off, please.
Yeah, sure. Hi, everyone. So Victoria asked me to give a few responses as someone who's thought about and researched and funded participatory or empowering data governance. Most of my thunder, I think, has been stolen, especially with the last slide. But I'll try my best to pick out some unique parts or some unique reflections. I think the first thing I found interesting was the focus on the process as much as the outputs. So I think I've seen different versions of this type of presentation where we start with the license, or we start with the mandate or the template that was produced, and actually it's the deliberation, the process that was gone through with the artists. I think that's important. So that's something I think personally I'll be borrowing, but we'll also look to see in other projects a description of the process as much as the output. Also keen to see something that kind of pushes beyond the binary of opt-in or opt-out or consent or not, and also something that's kind of more collective than individualized. I was going to make the point that we're talking under the spectre of a consultation on copyright as well. So wanted to ask, maybe back to the group, how did you deal with strongly dissenting opinions amongst the artists you're working with? And if it was the case that then their recordings, or they declined to take part in the recording, did we in fact create a de facto opt-in or opt-out just slightly further down the chain? That was something that came to mind when you guys were talking. This might be more for Cullen, but I was interested in the machine readability or legibility of the license that was produced. So I think we veered towards Creative Commons. Kind of curious about how this corresponds with the kind of machine readable rights that Spawning and Cullen and others are working on, and whether this fits or matches or kind of breaks that. I wanted to ask the question of. Sorry, Cullen. I think I have to get these done, and then it's your turn. What's the data worth? And I don't know whether I should be asking that question, but I will. I'm kind of curious about what that licensing regime might be intended to create beyond attribution and the moral rights that were described. And then, what does this governance look like over time? So something I'm thinking about quite a lot at the moment is, it's one thing to design a fairly sophisticated data governance arrangement at a static point in time, but what happens, maybe think about this as an artwork, when the artwork gets bought, does the purchaser of the artwork, are they able to change this governance arrangement that's been constructed? And just more broadly, what happens to data governance when people, priorities, funding changes over time? Maybe a question back to the group.
Okay, great. Well, I've noted these down, so hopefully we'll return to at least some of them, because I think they're very critical questions. But I also suspect that Colin might have interesting thoughts on at least a couple of things related to machine readability and also pricing of data sets in general. So Colin, here to you.
I just want to clarify, is this where I should give...
Yes, this is the 7 minutes of relative fame.
Great, thanks. So thank you for inviting me. I'm VP of Policy at Spawning. My name's Cullen. And I'm very honored to be included here with such an esteemed panel here at Serpentine, as this data trust experiment really exemplifies the kind of practicalities that we need around the data set construction and its subsequent governance, which is clearly lacking. This evening, I just want to make some comments on why we need better data governance and ownership structures to get more mileage out of the public data. And I just want to start sort of sharing my perspective on how we might navigate what researchers are calling the data wall problem in pre-training. And so what do I mean by the data wall? But so recent analysis estimates that the total effective stock of human-generated public text at around 300 trillion tokens. Research done by Epic AI has projected to show this stock to be, or it could be fully utilized between 2025 and 2032. And this doesn't really even factor in some of the forthcoming restrictions on data usage from the EU AI office and the UK Copyright Office. So let me just try to frame this technical challenge that frontier model providers are facing. In order to really make a stepwise change to the next tier of model, meaning like a GPT-3 to a GPT-4, we'll need 100,000 times more data than we currently have. And this obviously isn't just a theoretical concern. For instance, there's some research published by Villalobos entitled Will We Run Out of Data? That examined various types of data stocks, including common crawl, the indexed web, and private data like social media platforms, which is probably not even legal to train on in certain contexts because of GDPR. But even including these data sources, this total available stock falls far short of what the scaling laws suggest we'll need to make this next stepwise change. These claims have recently been corroborated by OpenAI's co-founder Ilya Skutsever in his recent NeurIPS talk, saying that we've achieved peak data, there'll be no more. We have to deal with the data that we have. There's only one internet. And basically this dynamic will effectively force a shift away from the way that models are currently trained today. Which I would argue is actually a good thing. And I think it's good to discuss it, particularly in this context. So there seems to be three sort of ingredients, broadly speaking, to scaling: compute, data, and capital. Scaling compute is a possible constraint, but it seems feasible, particularly with this renewed interest in nuclear. CapEx doesn't really seem to be an issue if performance keeps up. But scaling data, it's really unclear how this just doesn't plateau. And so major model providers are pursuing a few strategies to address this, including synthetic data generation, expensive licensing deals, self-play, and reinforcement learning. But these approaches face pretty fundamental challenges. So without getting into the details on that, I just want to basically say that this idea that we have quote unquote run out of retraining data for LLMs illustrates a pretty serious lack of interdisciplinary training in the tech sector. First of all, to anyone with a humanities background, it is obvious that the internet is merely the tip of the iceberg of human knowledge. The largest untapped resource of quality human data is, of course, our cultural heritage, preserved by libraries, museums, and archives. And for decades, these institutions and their employees have done the thankless work of digitizing historical works in spite of minimal interest and support from the wider public. And this can, of course, be generalized to projects like the Coral Data Trust experiment. The way forward to source and generate high-quality pre-training data is not to generate synthetic data, although that certainly will play a part for frontier model companies. But really to give the support and resources for public sector professionals, public initiatives, and institutions the keys to unlock the treasures of our shared cultural heritage and our future cultural ambitions. Some organizations that are doing this, aside from the Serpentine, are PLIUS, the Institutional Data Initiative, and the Library Innovation Lab at Harvard, and Eleuther AI, amongst some others. So if you combine this like library-based approach with public stewardship and equitable ownership, trusted data intermediaries, and some of the forthcoming mechanisms that Spawning will be introducing later this year to help bring new data into the commons, we expect this to fill a pretty critical gap for public AI, especially as a disconcerting percentage of the internet has recently changed its data permission policies as a result of web scraping for generative AI, resulting in a marked decline in the data commons. So looking forward, I believe there's just going to be a huge bifurcation into two different classes or categories of models, meaning large generalizable models and application-specific models. While, of course, the major model providers will continue to push the boundaries, doing their best to follow scaling laws, we'll continue to see growth of sort of consumer-facing specialized AI applications built on smaller, more focused data sets. And this isn't just a speculation. We're already seeing it with recent models showing carefully curated data sets with just 1% of the data achieving benchmark parity of previous generation state-of-the-art models with substantially less parameters. And I expect that we can extrapolate this as well. So small data sets and non-general, smaller parameter count models become more tractable and governable. This is good. They're also become more interpretable, which is a critical component for replicating results in open science. And this is a feature that is massively lacking from the murky web scale data sets with practically zero governance. Okay, so this brings me to Spawning's work, which tries to offer an alternative path to training models on indiscriminately scraped, ungoverned, and undocumented web data. We've built a fairly comprehensive governance stack for preparing and enriching data for training that extends beyond just our own private benefit. So this, we initially launched a Do Not Train registry, which at this point now has registered over 2.4 billion independent machine-readable rights reservations or opt-outs. These do not train assertions are integrated into Hugging Face, which is the largest host of public data sets online and is respected by Stability and other model providers. This integration has already prevented hundreds of millions of unauthorized uses of opted-out works for AI training, essentially proving that rights management can be implemented without creating friction in the development process. Last year, we launched Source Plus, building on top of this foundation of opt-outs to start to build a product and an ecosystem for opting in. We currently host over 40 million properly licensed images and try to demonstrate how curated data sets with persistent provenance can enable effective training, governance, interpretability, and just increased performance. And we're going to be continuing to build this out, integrating our forthcoming public diffusion model, text-to-image model, which aims to put these principles into practice by training on our PD12M dataset, which is composed exclusively of public domain data. These recent technical results have supported this approach. There's an architecture called Matryoshka diffusion has shown that careful architecture design and progressive training can achieve benchmark parity with limited data. PixArt Alpha has dedemonstrated competitive performance with just 12% of Stable Diffusion's training time and just 1.25% of its training data by progressive trainings. So these results suggest that the path forward isn't just about quantity, it's about quality and efficiency. And so Spawning's PD12M dataset exemplifies this approach. Unlike these massive scraped datasets and crawled datasets, it's built on approximately 12 million carefully curated and synthetically captioned public domain images. And despite its relatively modest size, models that we're training on PD12M are demonstrating strong zero-shot capabilities and competitive performance with models in their class. And our special sauce is not the volume of data, it's the quality and the clarity of licensing and its governance. Some researchers at Google have recently, I think last year, written a paper entitled "Everyone Wants to Do the Model Work and Not the Data Work." I think data work is generally seen as kind of being unglamorous or unsexy, and yeah, I think we need to change that. And I really appreciate the efforts of all the project that we're here today to discuss. I'm just going to make a couple comments about how this approach aligns pretty naturally with the emerging EU and UK regulations, particularly Article 4 of the Copyright Directive and the AI Act's evolving code of practice transparency requirements. Basically, by building from public domain materials and commons-based data and incorporating machine-readable licensing and governance from the get-go, we're trying to create infrastructure that's basically compliant by design rather than trying to retrofit it after the fact. We basically see setting up public infrastructure and data sets as a solution to both governance problems and this data wall or this data scarcity problem that I mentioned earlier. And by using a foundation of this commons-based data, clear provenance, proper licensing, and community governance protocols has enabled us to build what we think could be a template for European AI development or UK model development, given the EU's and perhaps the UK's stricter approaches to model development. By working with commons-based data, by definition, will force us to solve some of these critical governance problems by increasing the public's involvement. And of course, by increasing public stakeholders' equity and their literacy, I anticipate that this will give the public some bargaining power. In particular, it is almost completely absent from the current dealings on public-private data negotiations. Additionally, there's technical advantages, like I mentioned, the interpretability earlier, parameter efficiency, application-specific models can achieve competitive results with increasingly less and less parameters. There's also efficiency on data. So studies on transfer learning and domain specialization have shown that focused data sets can achieve comparable task-specific performance within, with 10 to 100 times less data. And yeah, this is a good trend for what we're calling small data. Also, just computational savings too, which is great when you start thinking about the requisite for some of these LLMs needing 10, 100 gigawatt data centers in the upcoming years. Okay, and just on my final statement here, basically, given some of these emerging technical and legal constraints, we believe that building from high quality, properly licensed data represents not just a responsible data ethos, which of course it does, but also it's a technically efficient path towards a state-of-the-art viable application-specific models. Our forthcoming small data text-to-image model we're calling public diffusion. It's aiming to demonstrate this by providing accessible market infrastructure to open source public domain models for fine-tuning and user ownership of competitive models using our Source Plus platform. Okay, thank you for your time and attention.
Yeah, great. Thanks so much, Colin. Okay, so just to start maybe tying together some of these contributions, I think, Alex, you mentioned that given the sort of slightly kind of lab cozy conditions in which we have nurtured the Coral AI data trust experiment, there is like questionable relevance to real world scenarios. But I think, what Colin is saying here is that in fact, if, we're going to see sort of a greater dominance of application specific models and actually the value attached to domain specific data sets that are well curated and where all the compliance issues are resolved and and kind of all the licenses in order, all of a sudden, we're seeing a slightly different ecosystem emerging than what we have seen in 2024. So I'm just wondering, from Callan, from Jack, from everybody else on the panel, how do you guys see this sort of evolution or development of what we're now calling this trusted data intermediary entity within this ecosystem? I mean, the way that we have sort of put it together, it's a very bootstrapped analog, kind of very early primitive, right? But I think what it communicates is that between an individual contributor, data contributor, and a model development process, there needs to be an entity of a different scale. And that entity needs to somehow both provide a standardization service to the course, to the contributors, and also be kind of a streamlining opportunity for the model developer. So I'm wondering, how you see the evolution of such entities, what support is required for them, both, I think, kind of on a policy legal level, but also on a technical level. How would that type of entity, for example, plug into the type of infrastructure that you're building, Cullen? So, if Cullen, because I know you can't see us, which is slightly awkward. But since you're sort of warmed up and if you have a ready response, happy to hear from you and then to continue the conversation here in the room.
Yeah, it's a great question. I mean, a vertical integration is required, and I appreciate. I mean, I think it has to start at this sort of scrappy, bootstrapped, rapid prototypey sort of thing where it's just messy and you're figuring things out. That's just how it always has to start. But of course, like you're suggesting, Victoria, the next question is, well, how does this integrate into like a real vertical? Otherwise, instead of just being a proof of concept. I think that remains to be seen. I mean, obviously, we would love to do more of this collective negotiation, and we are working with CMOs and other sort of larger trade bodies to bring data on board and onto Source Plus. And I think creating a user class for collective management of data is from a technical standpoint is actually quite, given everything that we've built already, it's quite easy. And we would love to onboard your data and start to catalyze and hopefully bring on more of these types of projects and build on top of the work that you've done too. So I think a partnership with us would be fantastic. But yeah, I mean, broader interoperability questions, I think, are obviously part of the question as well. And of course, the legal questions are abound as well too.
Yeah, Jack, please.
One way that I tend to think about this is applying the right level of friction to a data set, whether that's in its collection, use, sharing, or governance. And so I think as an experiment, incredibly worthwhile. I don't know how I would go about answering the question of where is this level of friction required for different types of data, whether that's friction necessary for reasons of risk, for reasons of value. I don't quite know, but that's where I go with that provocation is where is this the right level of friction to apply to the governance of a data set. And then the other is, and this is a bit dangerous because I'm not an expert in copyright, and there's people on the panel that are, is this kind of a mini collective management or licensing organization? So I went down the rabbit hole of looking up CMOs in various parts of the world recently, and this looks to me like a kind of emergent mini version of those, scoped at a kind of micro granularity. Am I on the right page or barking on the wrong tree completely?
Yeah, so it's interesting you should say that, because Victoria was speaking to a friend of hers at one point during the project, and the question was raised whether the trusted data intermediary was in fact within UK Collecting Society regulations. It wasn't, but it's interesting that we could find ourselves so close to that without really thinking about it much in advance.
And what are the implications of that, category collapse?
Well, it would just mean that we had a set of extra compliance obligations to cover. It would make the running of it more expensive.
Alex, any further comments?
Yeah, just on this thing of like, how's it going to develop or what's needed. I mean, I do think more pilots like this and more people talking about what they've done is probably quite crucial, because what you found was it's expensive and difficult to start doing this when you're starting really from a blank page and you don't know what you need to do. You don't even really know what the questions are, and then you have to like call up lawyers and ask them, and then it costs money. So I do think that more different experiments in like different contexts as well. This was a very actually turned out to be a very specific context, like particularly on the GDPR side with these Quora recordings and people not being identifiable. That's actually quite unique to a Quora recording scenario. It wouldn't be the same in other AI training contexts. So I think there's that. And then I think also in terms of how it will develop, I think it links to one of the questions, or actually two of the questions that Jack posed, which was like, what's the data worth and what does it look like if it to be sustainable? And do you think those are really linked? Because the data has to be worth something in order for a data intermediary to exist and be sustainable. You know, even a company limited by guarantee has to like file an annual confirmation statement and so on. So there has to be value there somewhere that can sustain that kind of intermediary, and that maybe suggests like a move towards like something that's quite concentrated, like a small number of intermediaries doing this for like a lot of big data sets to try to get enough value that actually sustains them. But yeah, it's just speculation really.
Yeah, I think this question of scale is really interesting because, you know, in theory, one could think, you know, every cultural institution of a certain level, right, has access to important data sets, in theory, right? But I do wonder whether from a perspective of AI training, this is sort of the right scale at which we should be thinking, or whether there should be more kind of concerted efforts at the sector level where there are a few intermediaries that kind of represent specific arts or specific media, which then kind of interface with further AI development pipeline. Yeah, I'm wondering whether, Callan, you have any thoughts of that? Like, what's the appropriate scale at which to think about trusted data intermediaries?
I haven't thought about it too much. I mean, I have thought about it a little bit in terms of like a user category in our product, but a lot of this is very much untested, and I think I apologize. Who just since I can't see you, I don't know who said this, but the question around around the data value being justifying the acquisition of the data or the generation of the data is, I think a big question here in terms of its ability to scale. So without having an actual market to test some of these, and I think that's probably a pretty important. We'll get some pretty important information probably in the next year as we get a better valuation on data as some of this becomes more public information. I think we'll have a better idea around just what the upfront costs, if they can be justified, and in terms of actually in making an investment into a project like this. But yeah, all of this is very novel and new, and yeah, I anticipate in the next few years the investment and the pricing of this will help determine the viability or the actual magnitude of with which it's viable.
Great. I wanted to turn to a very critical part of this project, which was kind of the human part of it, and it's building relationships. So this is the reason why the intermediary is called a trusted data intermediary, because Jen, in particular, was able to build sort of a relationship of trust with the participating choristers. And a lot of it had to do with addressing asymmetries of knowledge, understanding, interests very often. So I wonder whether you have any kind of insights in regards to that. You know, it's something we've discussed a lot. On the one hand, we have this kind of like market demands or ecosystem development demands, but on the other hand, we have the need to establish relationships with people who are going to be part of these processes. So what does that look like from your perspective?
Yeah, I think the thing I keep thinking in this current conversation is who is the intermediary for, and also who gets to define trust, right? Which are the crucial questions for a term like trusted data intermediary, a heavy term. In many ways, I think for us, the form of the intermediary really had to respond to the legal situation and for it to be legally recognized. So that's sort of a step one. But at the same time, the challenge with this project is to grapple with legal legibility, technical legibility, and human legibility all at the same time. And this is just sort of a balancing act that we're very much in the middle of. Some things maybe, for some things perhaps scale is a good thing, such as machine readability, right? That sounds like a great thing to scale. Other things much more challenging, like developing relationships with the 400 choir members. So I think at the moment, it's very much a big question mark in my head. Now we have this intermediary, we have the legal form of it, we have the people around it, we have the data set, the data contributors, and in the coming months, I think that's where we'll really start to begin to grapple with some of the questions that Jack raised too around what is actually sustainable, probably not having Zoom calls every week, but there needs to be some sort of touch point. We have had a request from one of the, I guess, more trusted AI developers that co-enlisted to access the data set in a nonprofit scenario. And so how do we make decisions like that have some sort of gate but don't require hours of deliberation every single time? At the same time, probably we won't be going for a fully commons-based approach where we just release the data open to everyone, because that's not what the data contributors were interested in. So I think I'm not really answering your question, but I think these are the questions that we are left with at the end of this that we will now hopefully be able to answer within the framework of a trusted data intermediary.
Yeah, fantastic. Great. I think unless you guys have any comments or questions to each other, we might open up to all of you for questions and feedback.
Hi, yeah, I'm Michael Veal from the Faculty of Laws at University College London. My question is around what happens when things go wrong, and particularly around enforcement. You know, as mentioned, this is a bit of a LARP, a bit of an unusual asymmetric, in the wrong way, a different way than usual, trusted environment. But you know, a lot of the actors who are involved in training things on these data sets do so without regard to licenses and do so without regard to robots.txt or without regard to all these kind of objection mechanisms that have been established. And Alex mentioned privity of contract, which makes enforcement by someone else very difficult or almost impossible. And the Information Commissioner's Office is very uninterested in getting involved in individual questions of someone who hasn't had their right upheld. They're much more interested in sort of bigger systemic questions. So thinking about that, what are the roles for other intermediaries in this space? Cullen mentioned Hugging Face. There are distribution intermediaries. If we're having data trusts or data intermediaries who are holding this data, should they have enforcement funding and the ability to go out and find this? Or should they be relying on other actors to do that enforcement for them? And what should that relationship look like? Should they be wealthy and endowed entities that are going to, like the Linux Foundation, try and work out who is violating their license? Or should they be somehow delegating that? And what should happen, particularly if the people who have entrusted their data in this way say, look, I see it's not being respected. Who are they going to? And who could they go to in a world that we might be heading towards?
Is there a legal response? Is there a general policy line response? I have some thoughts, but I just wanted to see. Yeah.
Well, I mean, I think it's difficult. There's some. I definitely think that you talked about money, and that is definitely part of it. Our day job at AWO is enforcing people's data rights, and it's really expensive. And you can do something where the ICO would agree with you if it was asked, but wouldn't do anything if someone came to them with a complaint. But will intervene in a piece of litigation on your side. But you need £1 million before you can even think about taking someone to the High Court. So there's an extent to which some of those problems on enforcement are soluble financially, but there's also an extent, particularly around jurisdiction, where there's probably no really good answer to that. If you've got someone doing something in China or Venezuela, then you're not going to be able to do anything about it. Certainly not under the GDPR anyway. So I think it's a mix. But if you're imagining a world where the intermediaries have lots of money to do strategic litigation, then deal me in. That sounds great.
Yeah.
I mean, unlikely to eventuate in the cultural sector, right?
There's a similar problem with IP rights in this context, in that, if someone infringes your copyright, maybe you'll get a reasonable license fee from them, or maybe they will compensate you on the basis of the profits they've made from their infringement. But if someone is training a model on gazillions of pieces of data and your works are some small part of that, it's not obvious that there's going to be much in the way of infringement damages. I suspect the answer is, from my perspective, I don't see I don't see the ICO doing this. I think what we probably need is to look again at how damages are calculated in these scenarios and add a punitive element so that individual enforcement can have some effect on the behavior of organizations' training models.
Thanks very much to the panel. Spelang Harris, independent consultant on digital rights. I was curious to hear more from the panel involved in the project about the transition or the development of the idea from a trust to the legal entity that ended up being formed as an intermediary. And I think one of the speakers mentioned that there was a sort of assumption at the outset, perhaps, that a trust would be the right kind of entity, and then as the thinking developed, that shifted. So I was really curious to hear how the individual choristers kind of interacted with that legal discourse, and whether part of the problem was trust, the word trust acting as a false friend, where it has a very particular legal meaning in legal discourse that was then implying something to normal humans that actually shouldn't be given to trusts as an institution, and whether the language of a trusted data intermediary, where you've landed, is a more accurate and more translatable kind of term between legal and human discourse.
Yeah, maybe I'll start from where we started, and then perhaps Alistair and Alex, you can pick up in terms of the reasons why we chose community limited by guarantee in our context. So I think what we were interested in from the outset was this idea of collectivizing individual rights, or collectivizing sort of the bargaining power of all of those involved in the data set. And this really came out of the research that we did for Future Art Ecosystems 4, the kind of ideas around the fact that individual data is not that valuable. What's valuable, it's the relationships between data. Yet there are no kind of real ways in which we can enforce that kind of collectivization, and therefore make use and leverage the bargaining power that results from it. So I guess in this respect, when we kind of framed the project, what we were framing was how can we collectivize the rights that we find in this setting, and try to use these in this LARP scenario as a bargaining power in order to, hopefully set more preferential terms for the data contributors. As to the details regarding the decision, we had to go to counsel, to a trust barrister, who explained to us why it would be prohibitive in our case to actually use trust as a vehicle. So perhaps, Alistair, I'll hand over to you, since we were part of this conversation, and you'll be more on point legally in explaining the reasons.
So when Victoria first came to me and said, well, we'd like to make a trust, my immediate reaction was, why? What would be the advantage of a legal trust in this scenario? I mean, as an IP lawyer, obviously we're very used to dealing with licenses. We can have license prohibitions and conditions and controls. Licensing is very flexible. What does a trust structure add to that? So we were sort of slightly negative about the idea, but I think we went to counsel, and he advised that rather than looking, I think, at the possible advantages, he just focused on the disadvantages. And the disadvantages were that you could, first of all, we either had to have an individual trustee or an unincorporated trust whereby individuals would be liable, which we didn't want for obvious reasons, or we could have a corporate trustee, which would be very expensive. And even if we went with the individual trustee, then that would create issues, depending on the precise form of the trust, with HMRC. So there seem to be expense and problems associated with a trust, and I couldn't for the life of me see any advantage of it. Again, you know, from an IP perspective, a trust is about separating legal and beneficial ownership of the IP, but we simply didn't need to do that. We could license it.
And I think maybe bringing it back home to Serpentine is that, you know, it was, since we had initiated this process, it also seemed that we were the best party to carry this process forward in terms of stewarding the data set and you know, being an interface between the data set and future users of the data set. So when it transpired that a company limited but guarantee is the best, kind of most optimal vehicle for the stewardship role, you know, most public institutions have some form of commercial trading entity attached to them in order to manage spaces as this one, you know, to sell books, et cetera, et cetera. And actually that seemed to be like an entity that's worth augmenting for this stewardship function. And also, and you know, something that I should have mentioned earlier, you know, this kind of template of cultural institutions using their trade-in entities in order to steward data sets that are under their guidance is actually quite a transferable practice, right? So in the end, it wasn't so much the choristers' decision, because from the perspective of the choristers, you know, we had to be transparent as to what choice we were making. But since quite early on in the process, and that was one of the many pie charts that Janice showed, there seemed to be a high level of trust both to Serpentine and to the artists because of our position in the project. You know, it seemed like a no-brainer to then use Serpentine's trading entity as the vehicle for the stewardship of the data set. Okay, there is a question right in front of me, so I'm just going to...
Thanks very much. Two questions, actually. It might be that I mishear, but it sounds quite important that you can't identify or hear any individuals that the AI model recreates or reproduces. So how do you guard against that, and who gets to decide? If one of our soloists turns up here and says, no, this sounds like my voice, who actually, and how do you guard against that and how you train the model? And is it just that Holly and Matt say that's not what we're trying to do, or is there some legal way you prevent it? That's the first question. And then, Callum, I think it might be. I wonder if you could speak a little bit towards the scalability of small, or let's say like high quality small data sets. So we have 15 choirs here. How many choirs do we need to make choir model 2? Do we need 15,000 choirs? Do we need 1.5 million choirs? Is 30 choirs? Like these small high quality data sets, how fast do they scale and how quickly do they iterate in terms of their quality?
Shall we start with the first one, Alex?
Yeah, so from the GDPR perspective, if you don't want to be in scope of the GDPR, then you do need to ensure that at the deployment phase, your model, if it's a voice model, doesn't sound like an identifiable individual. And that's an objective question. It's not a question of the intent of the artists. I mean, if it does sound like the person, from an objective point of view, then that probably would constitute processing of that person's personal data. I don't know if you've sung into the thing, but I don't think it sounds like a human. So I think with this model, it's not really a question, but it's something that on-model developers would need to be mindful of. And presumably there are sort of technical measures that can be put in place. You know, if you think about those face generators that generate faces that aren't humans, presumably there are controls in place to ensure that they don't simply serve up an existing face from the database on which they've been trained. I mean, I don't actually know, but I'm assuming they put those kinds of controls in place.
It might be trickier with things like visual art or something, where you would say, well, that actually looks like my artwork.
Yeah, that could be an expensive dispute, yeah.
Colin, for the scalability question, did you get it?
Yeah, I think so. I have not seen the benchmarks on the model. I'm not sure if they've even been done, so I can't speak in any sort of empirical terms about this. Unfortunately, I think that's probably the real answer. But I have heard the output of the model, and I guess it depends on scalability. May not necessarily be an important and the right question for some of these models too. Some of them are probably within an order of magnitude of the data required, I would guess. I think that it depends on what you want out of the model, but I think that the reason that these smaller models are interesting is because they have a smaller range of tasks. And I think once you hit that threshold of data to basically accomplish that task at a certain level of performance, I think obviously there's things that can be done to improve that. But it's relatively and there can be aesthetic dimensions and things like this that you may want to incorporate into it for as you're optimizing and whatnot. But once you've achieved that, you'll have a pretty good idea of sort of the threshold of scale and may not need to go much higher. So I think that's speaking obviously in an abstract, and the requisite for data will vary based off of the model's modality. I don't even know how much data went into training this model. But yeah, I don't know if that answers your question, but that's kind of my understanding of your question, the best I could do, I think.
Thank you. My name's Hannah. I'm a curator. I've been working with art and tech for about 30 years, and I also work at the Open Data Institute. And I'm slightly making observations, but slightly asking a question here as well, which is, I really like the idea of this being a small data model, where you're looking at rehearsing artists' rights and also rehearsing the legal language. I haven't read the copyright and creativity consultation. It's on my phone to read tomorrow. But it's really alarming and interesting to hear you say that the legal precedent breaks down as you start to look into the issues that this project raises, and to wonder if the UK government has an action plan for addressing that within the copyright and AI creativity thing. And then the question of artists, of data, individual data being not valuable, but what we're seeing with the opt-out and the opt-in is that individual data is extremely valuable to the people who are collecting data sets from individual artists who are not empowered to gain anything from that. And when I hear you talking about the economic rights, I think, well, if they want to opt in or opt out, if they want to opt in, what are artists going to be given for opting in? And in this country, which gives so little support to artists throughout their career while they build up a body of work that is valuable to a model, what payback do artists get?
Yeah, so the consultation addresses the question of licensing of training data very directly. There are other questions in there that it doesn't give such a clear steer on. For example, there's an idea or a concept in English copyright law of computer-generated works, which most other jurisdictions don't have anything equivalent. It's always been conceptually problematic because one of the core ideas of a copyright work is originality. So the work needs to be the author's own intellectual creation. And how can a computer-generated work be the author's own intellectual creation? So there's these kind of problems in it, and so the consultation is also looking at questions like that and how that would, how that might be resolved in the context of AI outputs. But then there's other questions that aren't addressed at all. I think a crucial question is whether AI models themselves get any IP protection. Are they protected as literary works, software maybe? Are they protected by the database rights? That's not clear at all. So, answer to your first question, some aspects of IP law might be cleared up by this, others almost certainly won't. And as to the question of the value, I mean, from a lawyer's perspective, again, a practicing lawyer, something has to have a certain amount of value to make it worth paying a lawyer to take it to court, and that is often quite a large number. That's the problem. So a right that doesn't have a certain amount of value to it, if you're never going to get enough money out of exercising that right to pay your lawyer to enforce it, is it really enforceable?
Yeah, well, I guess maybe this is perhaps the kind of good faith world of LARPing, a better ecosystem. But this is, I guess, where these intermediary entities that have more direct connection to specific communities whose interests they represent, but where they can also kind of create certain standardization around opting in and the different scenarios for opting in. So I think that's kind of what's missing at the moment. It's like, so you've opted out, but then you do actually want to partake in the AI ecosystem. Like, what are the pathways that are available to you, right? And so here we've tried to prototype like a particular kind of pathway that would be available. I mean, as you heard from today, it was a convoluted, exciting journey for me, boring journey for most people, but it was a very necessary journey, right? And I think kind of contending with, I guess, the kind of the level of nuance that will be required in order to have positive opt-in scenarios for artists. It's, this is what the cultural sector should get on board with. Like, otherwise, yes, once again, the train will depart from the station. So, Matt, there's one question from you, and then we're going to close. Oh, no, there'll be two questions. Okay, Matt, and then the lady over here, and then we'll close. And there's still, if you still want to get a drink after this heavy-hitting session, please do. We're around to chat. But Matt, on to you.
This is a question for the lawyers. I'm interested in, if we're interested in sort of maximizing the ability of these trusted intermediaries to act as collective bargaining type agents to sort of practically negotiate the ability for someone downstream to train or not train on a data set. I'm curious what you think are the most powerful and practical rights to delegate to them. So in particular, the text and data mining protocol opt-out, is that enough? Are there issues with the sort of practicability of delegating or assigning those rights to an agent, A, and B, do those rights have enough sort of teeth to enable the trusted data intermediary to make the practical sort of negotiating decision about whether or not this can be used in a model?
On the GDPR side, I think on paper the rights that exist under the GDPR probably do have enough teeth. So you have the right to object, and typically the kind of processing you might want to object to down the line from someone creating a new AI model is going to be done in reliance on their legitimate interests, and that's when the right to object under Article 21 arises. And it's actually even, people have questioned whether you could even rely on legitimate interests at all. So that suggests that the balance would weigh quite heavily in favour of the data subject who did exercise his or her right to object, including collectively through a third party. I think where it potentially falls down in terms of teeth is on what Michael raised around enforcement. And who's actually going to ensure that such objection requests are actually enforced? Is it the ICO, or are people going to start taking controllers and AI developers to court? It's like a little bit less clear. But yeah, I think in the AI training context, the key rights will be the ones that we talked about earlier. So the right to be informed and the right to object in particular.
Yeah. In the IP context, I guess things are a little bit different in the IP. When we think about copyright, we think of the value flowing downstream a little bit further maybe than the GDPR rights. So if someone is training their model on your copyright works and someone else is using that model to produce their own works and they're making money out of that output, perhaps you want to enforce those rights. And right now, we just don't have a very clear analysis of, the enforceability of those rights. Obviously, there's a lot of court cases going on in the US in particular, but also in the UK, to establish whether an output can be infringing rights or when an output would be infringing rights in training materials. Can an intermediary enforce those rights? Well, once we know whether they have rights, then in principle, if the rights, if we get clarity around where the where the rights are infringed. There's no theoretical reason why intermediary couldn't enforce them. You're just faced with the usual practical reasons, which is, jurisdictional problems. Is what is happening within a jurisdiction in which you have the relevant rights? Do you have the time, energy, money to actually bring a court case if someone doesn't fall over with the first legal letters? And these very, very few cases get to judgment, and there's a sense in which we often imagine that the world is conforming to our legal ideas, and then just with occasional derogations. But actually, there's very little real intervention of the power of civil law in what happens on a day-to-day basis. It's just these very occasional one-off cases that we hear about. And obviously they drive people's thinking about whether to settle claims earlier and so on. But I'm skeptical about how enforceable these things really are in an environment where you have different jurisdictions with different rules, particularly different transparency rules. So how will you know what anything's been trained on? I suppose a good analogy there is cloud services. You very rarely find copyright infringement claims over cloud services, and the obvious reason for that is that no one sees the source code. And so no one knows if any cloud service is infringing. And without international transparency about model training, you're in the same position with AI models.
Jack, you had a few words.
Yeah, I was going to make the point that it's been a fun legal lark, but there's another version of this conversation which would be around the technological stack of this artwork and this data set. And it wouldn't matter at all if a decision has been made deliberatively and really well about whether a third party should access it. And it doesn't matter if the agreement is as tight as can be, if it's sent over email or left on a floppy disk on the train. So there's the version of this also where we need to talk about the restrictions in concert between law and technology to ensure that the preferences of those who have donated, given the data in this case, that those preferences follow the data downstream, and it's not just a matter of the law to ensure that there's technology as well. And two kind of conversations that I struggle to reconcile sometimes, or there seems to be very few bridges between kind of discussions around trusted research environments, secure research environments for data sets to undertake analysis here, with the need to exert restriction around data for model training. So if you go on Hugging Face and play around with the hundreds of thousands of data sets on there, even the gated ones, it generally means you tick a box or you sign a very, very basic legal agreement. You're still downloading the data to your system, which doesn't to me look like responsible data stewardship or governance.
Okay, one final question.
Hello, I'm Olivia Williams. I'm an actor. I regularly sign contracts that say the producer owns your likeness as determined by the producer throughout the universe on any platform now existing or yet to be devised in perpetuity. And I sign that, and when I complain about it to my US attorney, he says, "Don't worry, Olivia, they won't enforce it." Is the unenforceability of any law surrounding this a reason to give up your rights and tick that box?
A big one for the conclusion.
We've maybe painted an excessively pessimistic picture of like the role of data and IP rights in terms of upholding individuals' interests. It's not that they're not enforceable under any circumstances, and there are interesting and useful things that can be done. Otherwise, I wouldn't have a job, or at least not this job. So I think actually just there are some really interesting interactions actually between GDPR rights and contractual negotiations and provisions of contracts, because if you're talking about specifically the processing of personal data that arises out of a contract, then actually data protection law has quite a lot to say about looking behind that contract and at its true purpose, and whether any processing of personal data done purportedly in reliance on it is actually truly necessary for that contract to be performed. So, it would be a very interesting question to see to challenge a kind of extracurricular, if you like, use of data that was collected in the course of an ordinary performance contract. Like if you like filmed an episode of TV or whatever, and then they started using the data for something else, even if the contract said, well, we can do what you like, and like we now own your data, I think it would be, there'd be potentially quite strong grounds to challenge that, because that extraneous use of the data wouldn't really be, strictly speaking, necessary for the performance of the contract into which you'd originally entered. So
I'm not really, I don't want to get into sort of individual legal advice, but thank you very much. But what I feel very strongly, particularly with this data mining law that may come in, is that this principle that because it's too difficult and it's already gone, we should stop protecting our own rights. And from what Callum said, which was so interesting on this point, the ship's already sailed. So let's not take away our right now, because we don't know what's coming down the line. So let's keep our right to own our own voice, our own body, and our own work for the work that Callum's doing about really specific, interesting work that's coming down the line. The ship sailed for the 24,000 tweets I've sent out unwisely in the late 90s. But from what Callum says, the law is changing. We are so far behind legally that we should protect the rights we have now, because we don't know what the implication is of giving them up now in the future.
Colin, do you want to nuance that?
Yes,
or not?
Absolutely.
Welcome, Matt.
Yes, absolutely. And I will try to bring a little ray of hope into this, that there is a possibility of enforceability. So earlier this evening, I was in the transparency working group for the AI office. On Friday, I'm going to be part of the copyright working group. We're currently the AI office is currently drafting a code of practice. I am optimistic that that it is worth reserving your rights on this. And the reason being that there is a market entry requirement for all models that enter the European Union. The European Union is the largest market in the world. And that is an opportunity that these companies cannot forego. So they will be complying with Article 4, the text and data mining exception. And so reserving your rights, however that may be interpreted, which will be finalized in April and come under enforcement this summer. The model training companies basically will be complying with that. And you might say, hey, I'm not in the EU. And I particularly tell this to US rights holders because they're pretty deflated. It seems like the opt-out will be adopted in the UK, which is obviously where you all are and where your representation is. But I think even if you are outside of a jurisdiction, there is a jurisdictional arbitrage opportunity due to the capital expenditure on training these models, right? These models cost hundreds of millions of dollars in most cases, and is increasing sizably. So they're not going to train multiple models. So basically, the world will get a European Union regulated model just due to the sheer costs of training them. So I don't know if that makes sense, but there is sort of this arbitrage opportunity to use EU law to protect yourself as this happens. And again, it is worth considering that these because of the expenditure required on these, there will be a time delay. But of course, as these models progress, older models, we're not going to use them anymore. Right now they're state of the art, but as this progresses, if you do use the opt-out mechanism, which we have basically built and served a lot of rights holders and data providers with already, then as the models come down the pipeline, and if these opt-outs are respected, then then your likeness will indeed be scarce and absent from these models. So that's my optimistic take. I have a pessimistic take as well too, but I'll try to leave it on the optimistic one.
Let's leave it optimistic, and yes, cheers to the Brussels effect. That's a good note to leave on tonight. Thank you so much for sticking around, for participating. Hopefully chat to you either here or further down the line. Jen and I will be releasing a white paper that summarizes everything that has taken place as part of this experiment. So we'll send you a copy. Would love to hear your feedback. So once again, thanks to the panelists, thanks to all of you, and see you around.